battles. If you've noticed, if you track the decision in New Jersey about their assault weapon ban and about their magazine limitations, that was knocked down. If you're tracking case after case, these aren't just nibbles around the edges. These are real attacks on the efforts, the core efforts of the gun controllers in recent years to ban semi-automatic rifles and normal compatible.
Self-described aficionado of personal freedom. I'll kick in for that. He's also a hard-ass desert anarchist, which is exactly who you want on this story. JD joins us live here now on the Wake Up America show to talk about suppressor tax being zeroed out. Good morning, JD. Welcome to the show.
Good morning to you.
Glad to have you here. So the big, beautiful bill, turns out there was something beautiful about it, zeroed out the suppressor tax in January. Then a Texas judge ruled that because there's no tax to collect, that this whole registration scheme for us to have suppressors has no constitutional leg to stand on. So the DOJ apparently let this appeal deadline pass. Thank you, Trump. So talk to us about this. The mechanism is kind of funny. The NFA didn't fall because the court finally agreed suppressors are protected. It fell because Congress zeroed out the tax, right?
Yeah, I mean, this was really interesting. The original plan last year was actually to delete a lot of the NFA, to remove silencers and short-barreled shotguns and rifles from the NFA, except that because of parliamentary rules in Congress, they weren't allowed to make that move. What they could do is simply reduce the tax in the NFA, the National Firearms Act from the 1930s, to zero. And the thing is, that law was passed with registration requirements that were justified as means of tracking who paid the tax. Well, if there's no tax to be paid, there's no justification to continue federal registration and paperwork on suppressors and other devices, short-barreled shotguns. So the rationale for keeping this, because it was a tax law, and keeping the registration requirements was gone, absolutely gone. And the district court saw that and issued a nationwide, well, it's a limited injunction. You can't really do nationwide injunctions anymore, but an injunction that applies to a couple of vendors, the silencer shop and several, and the plaintiffs in the case, which included some firearms rights organizations. So it's really a great decision based on a clever legislative move.
Okay, so after years of legal finagling, we finally got the ability to buy suppressors, maybe because the confusion is, JD, is who is covered by this. You say you can't do nationwide injunctions anymore, yet I have a 3D printer sitting over my shoulder right now that says I could just make one right now and not tell anybody. But the problem is, JD, that some people say that you have to be a member of the Gun Owners Association, GOA. Some people say that you have to live in certain states, and a lot of people that I trust on this issue are contradicting one another. So what the hell does this even mean? Who can do it? Who can buy one? Who can't? What's the news?
It's actually kind of messy. The good news is that you can go ahead and 3D print that just the way you can make a gun at home, because now suppressors are not subject to the NFA, so you have to register them at a federal level. They're treated as firearms because of the Gun Control Act of 1968, which means if you go to a store, and again, this is the covered groups, and I'll get to that in a minute, but if you go to a store, even as a member of these covered groups, GOA, I think SAF is in there too, you would have to still fill out a 4473 because it's a firearm legally, even though that's nonsense. And you still have to undergo a background check unless you have a CCW. But, you're still, since you're allowed to make firearms at home, not do any background check and registration, yes, that 3D printer of yours could go ahead and knock one out. In terms of in terms of who's actually covered by this injunction, it's limited to customers of the silencer shop, members of the plaintiff organizations, and I believe residents of several states, including South Carolina. It's a mess. A lot of injunctions are messes now because you have to kind of parse who exactly the injunction applies to. It definitely applies to customers of the silencer shop. It definitely applies to members of the plaintiff organizations, including if you were to go out and join today. There's no limitation saying you had to be a member prior to the lawsuit. So you can go ahead, join, pay your membership fee, and you're covered. Now you used to have to file a 4473 when you buy a suppressor, no tax, no federal registration. So in that sense, everybody can benefit from this, which is very nice. But yeah, you want to be careful. You'll find that a lot of vendors are being very careful right now because they don't want to run afoul of a misunderstanding of a federal injunction that does not apply to everybody.
Okay, so man, that is confusing. So you are covered if you're a member of Gun Owners of America, or if you're a customer of the silencer shop. So, but you can get covered if you buy something from Silencer Shop. So if I go and I buy a keychain from Silencer Shop today, in theory, that should make me someone who should be covered under this injunction.
Well, honestly, if you were to go to one of Silencer Shop's retail stores and go to purchase a suppressor from them, it's covered because the Silencer Shop was one of the plaintiffs. So the Silencer Shop is, as a vendor of suppressors, has a special status right now since they were a beneficiary of this injunction. All of their customers, including new walk-ins, can benefit from this because it applies to the Silencer Shop.
So if I go to the Silencer Shop, if I go to one of their locations, they are not going to make me fill out a form. But if I go to any other shop, they will make me fill out the form.
Even at the Silencer Shop, you still have to do a 4473 and a background check because legally, under a separate law, the Gun Control Act of 68, it's still a firearm, which is, again, ridiculous. But that is a lot lower hurdle than having to file federal paperwork and have it registered in your name, and then maybe not even be able to pass it on to your kids unless you set up a suppressor trust, which is actually a legal thing.
I remember,
where you
yeah.
don't. Yeah, you don't own the suppressor. The trust you set up owns the suppressor, so then your kid can get it as a beneficiary of the trust.
I remember
it gets
this.
really complicated.
Oh my
Yep.
God. Yeah. I remember guys going to gun stores and like listening to them explain how if you want to get a suppressor, you don't want to do it yourself. You want to set up a trust first and then buy the suppressor for that trust. And then the and all it did was create all of these legal like hurdles and financial hurdles that you had to go through. But are you saying, could you, if let's say you went and you bought a suppressor today, could you walk out with the suppressor today? You'd have to fill out the form, but you could leave with it today. You no longer have to send it that paperwork to the ATF and then wait 6 months for it to be approved and then go pick up your suppressor 6 months later. You can have it today.
Correct. Yeah, it's controlled the same way that purchasing a firearm in your state is controlled now, assuming you're a beneficiary of the injunction. So you'd go in, and if you're in most of us live in no waiting time states, so we don't have to do like a 2 week wait or whatever it is. As long as you file the usual paperwork, a 4473, as you would for buying a handgun or for a rifle or shotgun, and then if you're subject to a background check, if you don't have a CCW, a controlled carry permit, you would have to go through that too. But yeah, then you could just walk out once that is done. You don't have to go through the federal paperwork. You don't have to do the federal registration.
Okay, well that makes a little bit more sense. So then the good news is that you have to fill out the form, but you don't have to pay a $200 tax stamp, and then you can walk out with your suppressor that day. Now, what impact is this going to have on the suppressor market? Does this mean we're not going to have to pay $1,000 for these things? Is there going to be a glut? I mean, what do we expect to happen to the marketplace for suppressors?
Well, anytime you remove barriers to entry to a marketplace, both for customers and for vendors, you encourage competition. So right off the bat, for the last year, that $200 per suppressor tax is gone. Also, the long wait times have diminished. They were down to like 10 days or something, which sounds ridiculous, but compared to the 6 months or a year people were doing a couple of years ago, waiting for federal paperwork to come back, that was an improvement already. So now, if we're going to a market in which suppressors are treated like firearms, I would assume that you're going to get new entrants. you're going to have more people interested in doing this because a lot of people, I mean, myself included, looked at it and said, you know what? I really don't want to have to set up another trust, drop four figures on an attorney to do that, and then jump through the paperwork in order to buy one, two, three suppressors, whatever it's going to be. It's just too much of a hassle now. Well, that hassle is gone now. So you're going to have a lot more customers entering the marketplace. I'm looking at it myself right now. So yeah, prices should come down. That was the basis of your question. Prices should come down.
I love that. I was making the joke the other day because we were talking about like how boomers control all the wealth in the country. I was saying, man, if you really want to stick it to the boomers and their wealth, you should get rid of the 1986 Machine Gun Act, because all of the machine guns that are like $50,000 to $25,000 that are transferable would suddenly drop in value, which would represent a great loss of wealth to the boomers who can actually afford to own like a Mac 10 or a Uzi or a Galil or what have you. But let's not dunk on the boomers right now, JD. Let's talk about the law, because the judge in this case, Judge Hendricks, wrote 66 pages, but he went out of his way not to answer the Second Amendment question because he left open whether a suppressor is even an arm. Okay, so then what's the next stage of this fight? You know, when do we have the lawsuit that asks the question about whether or not a stupid piece of plastic on the end of my gun that I'm going to 3D, I may or may not 3D print today, NFA, if you're listening. When are we going to have that fight about whether or not these things even count as guns?
You know, that's a great question. Both the plaintiffs and the reason the judge did not address the Second Amendment is the plaintiffs and the defendants had agreed not to go to the Second Amendment question if it could be decided on the tax question. And in law, you generally want to limit your cases to something that is clear, palpable, and narrow in application. The broader it is, the more your cases, the more likely the courts are going to turn it away. So that's why the defendants and the plaintiffs had stipulated that they wouldn't go to the Second Amendment. So we have to wait now on another lawsuit. Somebody is going to have to sue and say, you know what? You're making us file 4473s and go through background checks on something that looks like it dropped off the shelf in a hardware store. And that's ridiculous. I mean, it doesn't fire. It is not a firearm. It does not satisfy any palpable definition of a firearm. Somebody's going to have to file that lawsuit. But when you're doing law, by and large, you nibble away at the edges first, and you work your way toward the middle. And this one was kind of a big chunk out of the edge. Yes, it was a tax decision challenging a law that was written as a tax law. But since the gun controllers chose to treat it as a tax law, the challenge to it had to be filed as a challenge to a tax law. The Second Amendment case is the one that's going to come next, and that'll be really interesting because if you're going to define a pipe, which is basically, with baffles in it, as a firearm, anything can be defined as a firearm. And there's a real, I think, basis in there for challenging that and saying, look, you can't pass a gun control law on things that aren't guns. It has to actually be something that satisfies the definition. And we'll see. I mean, that will happen, but that's not in the courts yet.
Here's a really specific question for you. We've been talking about suppressors, but if we had this, if this legal scenario that we find ourselves in now had existed back in the 1980s, would Randy Weaver have even been killed by the federal government?
No, this whole thing, I mean, the Weaver case is absolutely maddening because it was a disgusting abuse of power based upon the violation of a ludicrous law. To refresh people's memory, I mean, most of your listeners, probably remember the details of that, or at least the basis of it. But it was all about Weaver being badgered into a commercial transaction in which he agreed to cut off, the barrel of a long arm. And it cut off, and if I remember right, the feds ended up measuring it, and it was still a hair beyond the limit. So they ended up taking off the butt plate, and that brought it down below the limit, which is ludicrous. I mean, why would a short-barreled rifle or shotgun suddenly be a felony? And the reason why is because that was an artifact of the original drafting of the National Firearms Act, which was intended to ban handguns. So any concealable short firearm. That part was excised. They realized they couldn't pass a ban on handguns back in the 1930s, and they left in the language that applied to shorter long arms, which is a weird artifact because you can own a handgun, You can own a long arm. What you can't do is own kind of that weapon that occupies that space in between, which is a shorter barrel rifle or shotgun. And that is what they got Randy Weaver on. And yeah, that never would have happened if this case had gone through in the 1980s or early 90s, in which case he would have just been cutting a pipe and it wouldn't have been illegal.
Now, because I'm a I have a fascination with things that go bang, like every normal man in this country. I did the whole buy an AR-15, but put a rubbery tip on the end of it rather than put a normal stock on the end of the AR-15, because for the reason of catering to people who have disabilities and could not fire or shoulder an AR-15 normally, you could get an AR-15 that had a short barrel if you were to put a brace on the end of it for disabled people and not a stock on it. So does this mean now that I can go and take that rubbery disabled person's brace off of my AR-15 and maybe 3D print a normal plastic stock to put on it?
You should be able to, because that is covered under this. That's a short-barreled rifle or shotgun. Would I do it today? I might wait a little bit and have the attorneys for GOA and SAF kind of sound off and work out the parameters on this a little bit. There's no reason why you want to end up as the test case for this. Well, unless that's what you're setting out to do.
Yeah, maybe.
But for right now, that AR-15 pistol that you own with a arm brace on it is actually very handy as a stopgap measure until such time as the courts recognize that the stupid rule is gone and that you can own a short-barreled rifle. At which point, all of those pistols are going to morph into short-barreled rifles. But that may or may not have happened with this decision. I think it did. I think you're safe, but I'm not an attorney, and I wouldn't play one on TV.
If anybody in Washington, D.C., in the liberty community that doesn't actively hate me, if there's any of those people left, then reach out to me today. Maybe we can get a case. I think the Institute for Justice might be interested in taking something like that. I know they deal with more of the economic cases, but perhaps we can get a gun case going. And now we've got Brandon Herrera in Congress. So we do have a little bit of the gun community is making some strides, JD. I think
absolutely.
We are winning some battles, aren't we?
We are winning almost all the battles. If you've noticed, if you track the decision in New Jersey about their assault weapon ban and about their magazine limitations, that was knocked down. If you're tracking case after case, these aren't just nibbles around the edges. These are real attacks on the efforts, the core efforts of the gun controllers in recent years to ban semi-automatic rifles and normal capacity magazines. And one by one, their attempts are being knocked down. Now, there are some mismatches in terms of the decisions between various circuit appeals courts, which means that the Supreme Court is going to have to take one of these cases soon and decide whether AR-15s are protected by the Second Amendment, whether normal-sized magazines are protected as accessories to these firearms. I think that given the makeup of the court, unless something changes dramatically between now and that decision coming down, the Supreme Court's going to give us a very strong Second Amendment decision because you do have these mismatches between the circuits.
Okay, so what I've learned today is 3D print the suppressor, okay. 3D print the stock for the pistol and turn it into a short-barreled rifle, not okay just yet. Maybe wait on that one. Sawed-off shotguns, I know we talked about that within the Randy Weaver case. So sawed-off shotguns okay to saw off today, or maybe wait on that one?
Again, sawed-off shotgun. And by the way, I'm printing that suppressor. I would send in my membership fee to one of the plaintiff organizations first to make sure you're covered by that decision, right?
Yes.
Okay. But yes, sawed-off shotguns are covered by the NFA decision. The items that are not covered are machine guns and destructive devices because the taxes on those are still in place. So the tax law still applies to machine guns and destructive devices. But yeah, short-barreled shotguns, sawed-off shotguns, sawed-off rifles, those are covered under this decision.
Okay, good to know. Just filled out the form for my Gun Owners of America. thing there. Thank you for that. I think this was really good information, JD. The Supreme Court has been loath to take gun cases in recent years. I think that they felt like they got it with McDonald, Chicago, Bruin, and all of that. Do you think there's a chance they'll take it anytime soon? I mean, they have to, but they've been sort of like backing away from gun cases in recent years.
They have, but I think they've let the kind of this backlog of lower courts openly defying Bruin in particular. There's a lot of laws on the books around the country in places like Maryland, Illinois, New Jersey, where the Supreme Court is openly being scoffed at. Hawaii flat out said the Second Amendment doesn't apply in Hawaii, and it doesn't embrace the aloha spirit, so they're going to do their own thing. And Hawaii got slapped down for doing that. You're not allowed to say we're explicitly going to ignore a Supreme Court decision because it doesn't work with our local political preferences. So with enough of these laws on the books that defy earlier Supreme Court cases, and with enough lower court decisions saying that these laws defy Supreme Court decisions, the Supreme Court is in a position where if it wants its decisions to have any force, it's going to have to take some big overarching cases and actually say, yeah, we meant it. And these laws are null and void.
This is exciting stuff, JD, especially for like gun nerds. I know you're a big gun guy too. Is there anything though that you think we might have missed in this conversation that you think is important, or maybe just something you want to share before we let you go today?
Yeah, the makeup of the Supreme Court. A couple of the justices on there are getting older, Thomas and Alito in particular. If the Senate is lost to the Republican Party in the midterm, then it's going to be very hard once Thomas and Alito kind of age out or pass away to get strong pro-Second Amendment justices onto the Supreme Court. And then there's anybody's guess what's going to happen in 28. So we have this window of opportunity now while the Supreme Court has its current makeup, but that current makeup is not a law of nature. It lasts as long as it lasts.
Good to know. JD, you're doing a great job over there at Reason Magazine. We love reading your pieces. Thank you for being so generous with your time and getting up early and talking us through all this stuff. We really